Take in the small town atmosphere, be amazed at all that we grow. Like our kids that go and see the world and can't wait to return home. Drop a line in a placid lake or stroll along the shore. Take a tour on a peaceful country road and bound to be back for more. Of Norfolk, Norfolk, my Southern County home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger along. With hard work, we built a dream that only willing hands could do. It's on display at our fall fairs and at all the festivals too. Erie beaches, Carolinian forests, where the flower and dogwoods bloom. Patchwork fields and rolling hills, it's just the place for you. Norfolk, Norfolk, the Southern County home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger along. Norfolk, 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 you won't be a stranger along. On a strip of sandy soil lies a county called Norfolk. It's Ontario's south coast, you know, and it's surely not remote. If you pass through or spend a day or decide to call it home, you'll see why we love it here and are proud to call it our own. Norfolk, Norfolk, a Southern County home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger along. Take in the small town atmosphere, be amazed at all that we grow. Like our kids that go and see the world and can't wait to return home. Drop a line in a placid lake or stroll along the shore. Take a tour on a peaceful country road and bound to be back for more. Of North, on a strip of sandy soil lies a county called Norfolk. It's Ontario's south coast, you know, and it's surely not remote. If you pass through or spend a day or decide to call it home, you'll see why we love it here and are proud to call it our own. Norfolk, Norfolk, a Southern County home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger along. Take in the small town atmosphere, be amazed at all that we grow. Like our kids that go and see the world and can't wait to return home. Drop a line in a placid lake or stroll along the shore. Take a tour on a peaceful country road and bound to be back for more. Of Norfolk, Norfolk, my Southern County home. Norfolk, Norfolk, we know you can't go wrong
talking about you. Is everything. Good afternoon, everyone. We're back. We did start our council meeting today at 3 p.m. Just before we get to our applications under our public meetings, I would just say that if you do have a cell phone with you for our guests, if you could just maybe silence it so it doesn't interrupt our proceedings here, that would be appreciated. I now officially open the public meetings. They are held under the Planning Act and the Municipal Act. I advise everyone in attendance that the Ontario Municipal Board has the power under the Planning Act to dismiss an appeal to either a zoning bylaw or an official plan amendment if the appellant does not make oral submissions at the public meeting or does not make written submission to Norfolk County Council before the zoning bylaw is passed and/or the official plan amendment is adopted. I would also advise everyone here in attendance that these meetings are televised and web streamed, and all items discussed this evening are a matter of public record. I will go now to Staff Report DCS 1739. It's on page 28, gentlemen, of your agenda. This is an application that we have received to amend Norfolk County official plan and the Norfolk County zoning bylaw to permit development of a single detached dwelling within a specific building envelope in the hazard land designation and zone. The applicant also requests relief of sections 311(1) of the zoning bylaw, to permit development on lands without frontage on an open, constructed and year-round maintained street. Paul Murphy and his agent, Thomas A. Klein, has put forth the application affecting the lands described as Gowrie Street in Port Dover. I officially now open this public meeting upon DCS Staff Report 17-39. Yes, Kayla is here. Pam, did you wish to speak? You may.
Thank you. If appropriate, Mr. Mayor, through you, Kayla would like to present both DCS 1739 and DCS 1740 together.
Together? My goodness, this is a first. So two separate applications will be, you wish to deal with them together. I know they're side by side, east and west of each other. Okay with that, Council? Let's proceed. This is a first.
Perfect. Before Kayla presents her report, Chris and I have a little introduction to how we got here with this application.
Could I also, before, and I apologize for interrupting you, could I also just read out the staff report 1740, which will be dealt with at the same time, if you don't mind? Okay? I think. Again, the other application we're going to deal with simultaneously is an application that we have received to permit development also of a single-family detached dwelling within a specific building envelope in the hazard land designation and zone. The applicant also requests relief of section 311(1) of the zoning bylaw, and this is to permit development on lands with frontage to an open, constructed and year-round maintained street. Robert Harris has put forth this application, also affecting the lands described as Gowrie Street, Port Rowan. And just before we continue, Pam, to you. We will deal with the recommendations separately. I will go through the procedure after you present the reports. Any questions? I will go through and I will refer to both applications. Okay? Is that fair? It's a new one on me. Pam, back to you and Kayla. Thank you.
Thank you.
Yes.
I think you said that Gowrie Street was in Port Rowan, but I think it's in Port Dover.
Boy, if I said Port Rowan, I apologize, and thank you for correcting me, because Gowrie Street is in Port Dover. Thank you, sir, for that. That's important. Okay, we'll see where this goes. Okay.
Thank you, Mr. Mayor. Before Kayla presents her report this evening, Chris and I wanted to take an opportunity to explain to Council how these applications came to be in front of you tonight. Application 39 in the name of Paul Murphy is actually one of the 4 outstanding appeals that we have with our comprehensive zoning bylaw. And as you can see on page 2 of that report at the top, there's the wording of the appeal itself. And the appeal relates to the hazard in particular of this property. In preparing the appeal towards the Ontario Municipal Board, we recognized that there was actually 2 challenges with development on this property, one being the hazard and the second being developing on an unmaintained and unopened road. So we have come to the conclusion with the applicant and his agent that the best process would be to come before council with an application that dealt with both challenges of the development. You'll see in Kayla's presentation the hazard has been more or less dealt with. The road issue is still outstanding. So depending on what happens tonight, that may lead into how the appeal is handled through the Ontario Municipal Board. The second application, application 40, is a new application. It's a neighboring property who's chose to come forward at the same time because the hazard challenge is the same for that property, and so is the road. So I know Chris wants to speak a little bit more to the road issue in particular.
Thank you, Mr. Mayor. Thank you, Pam. In 2001, when Norfolk County was created, I was the first roads manager for the county at the time. And for over 3 years, working with the residents down on Cumberland Lane and having to deal with a number of similar roads like that in the former city of Nanticoke, where they did permit, they approved building permits on open, unmaintained roadways. So we've gradually been picking them off. Mr. Klein will probably share other examples. They do exist in other parts of Norfolk County. In this particular case, these are sort of the last remaining lots at the end of the roadway. They are obviously of value overlooking the lake, so there's some clear understanding why the applicants are hoping to move this forward. In discussions with Lee Robinson, I won't speak for her, but clearly we need to come up with some sort of solution about how the roadway will be maintained. So it's important to think of the planning report that Kayla will present here shortly, but also from a land use perspective, but the road piece is something that may need some further discussion. And Ms. Robinson is certainly an expert in that regard, and maybe questions will come up and we can try our best to answer those. So with that, I turn over to Kayla and she can present the report.
Thank you. So the applications before us tonight are official plan and zoning amendment applications to permit development of single detached dwellings with a site-specific building envelope in the hazard land designation and zone. The applicant also requests relief to permit development on lands without frontage on an open, constructed, year-round maintained street. The subject lands front onto Gowrie, an unopened and unmaintained road just outside of Port Dover. The lands are vacant with some trees and are surrounded by Lake Erie to the south. There are 2 other existing dwellings on Gowrie, and these lands are accessed off of Cumberland Street, which is also an unmaintained road. So the images I have up here right now, the image on the right is looking down Cumberland, and the image on the left is Gowrie. It's Gowrie at the point where the 2 lots would then access. The images in front of us now are simply just a few shots of the lots 1 and 2 Gowrie, where the dwellings are proposed. And then the following images here are the 2 existing dwellings on Gowrie. So the image on the top is the dwelling on the north side of Gowrie, and then the bottom is the south side. And you can see that there is a graveled portion leading up to the 2 dwellings. So, in terms of the provincial policy statement, a slope stability assessment was completed, and this scientific study indicated that both lots 1 and 2, for both lots 1 and 2, a single-family dwelling may be constructed uphill of the established top of slope without any negative impact of the slope stability from a geotechnical point of view. This study was also reviewed by Longpoint, and as noted in the report, the development as long as the development takes place within the building envelope, they have noted no concerns in this regard. So for these reasons, planning staff are satisfied that the applications are consistent with the PPS. In terms of the Norfolk County official plan, the application does not satisfy all hazard land policies, specifically the one which deals with safe access for people and vehicles during times of emergencies. During winter months, Cumberland and Gowrie could potentially be inaccessible due to lack of snow removal. And this access concern was noted from comments from our fire division. It's planning staff's professional opinion that an unmaintained road does not address the policies and therefore development does not have safe ingress and egress. Construction of a dwelling on lands without adequate frontage on an open and maintained road does not represent good planning and is not in the public interest. The lack of proper ingress and egress creates safety concerns, and access for residents, services, and emergencies are critical. Norfolk County zoning bylaw, section 3.13, deals with frontage, and as mentioned, the proposals do not have adequate access and therefore do not meet the requirements of the zoning bylaw. Our Public Works Division has outlined 2 options in terms of the road issue. It should be noted that I have been contacted by almost all of the abutting property owners, and for the most part, the concerns from these neighbors related to the road access. Overall, the proposed amendment is not in keeping with the intent of the bylaw and does not conform to the official plan. The amendment could set precedents and affect other properties in Norfolk County without adequate frontage. And for these reasons, planning staff recommend refusal of the applications.
Thank you. Now, on the Murphy application, I recognize Mr. Klein is in attendance, so I'll get to him, and I also know that the applicant, Mr. Murphy, is here. And I also will ask Mr. Harris, you are here for this application, correct? Yeah, no agent. No, but you don't have an agent for this. You're looking after this yourself. Thank you very much. Mr. Klein, before I get to you, I'll just ask council members if there are any questions to staff on either one of these applications at this point. Councillor Geisens.
Thank you. I hear there is room for a house on the top of the bank, I guess, but what's getting to me is there's 2 houses on that road, and now all of a sudden there may be 2 additional houses there, but all of a sudden we're going to have a problem with the winter. That really is, we're going to have it whether there's 2 houses or 4 houses. So why is there such a difference, I guess? Thank you.
Through the mayor, it's my understanding that some of the residents do have an agreement between each other in terms of plowing and maintaining that road. But through my report, the safety concern is that there's never a guarantee for any snow removal during the winters if emergency vehicles did need to enter.
Councillor Oliver, please.
Thank you, Mr. Mayor. My question doesn't, although it relates to the roads, but it doesn't necessarily just relate to the 2 lots in question. I'm looking at map number 1 on the report, and I know as part of the staff report, staff sort of gave us a status on the various lots that are located on Gowrie. And am I correct in thinking then that I believe lot number 10 and lot number 6 could potentially be built upon as well, subject to the road issue? In other words, they're on the north side, so they're that much further away from the hazard area. So for those lots, would it strictly be a question of road access which would then potentially open up those 2 additional lots to be developed.
Through the chair, yes, that is correct. Lots 10 and lot 6 are zoned properly in terms of being agricultural zoning, so it would just be the road frontage issue that
Okay.
they would need to address.
And to the best of our knowledge, both staff and council, we've not had applications from the owners of either of those lots to date to get building permits and to build homes. Is that correct?
Through the chair, yes, that's
Okay.
correct.
All right, thank you.
Councillor Black, then Brunton.
Mayor Luke, thank you very much. Through you to planning staff. And I just wondered, a report made reference to setting a precedent. Could you expand on the precedent and how it would affect Norfolk County and Norfolk County taxpayers in terms of putting them more at risk?
Through the chair, there are many other opportunities where there are lots without adequate frontage in Norfolk County. In terms of setting precedent, basically if these were to be approved, there are many other opportunities where property owners may want to come forward with the same request.
For that. And I know this has been an ongoing situation for quite some time. I'm just wondering, why don't the people get together and build the road? That seems to be the biggest issue. Put the road in, and then everything's fine. I don't know if you can answer that or not.
Through the chair, I would direct that towards Lee in Public Works.
Do you want a response from Public Works?
Sure.
Thank you. Lee, could you care to respond to Councillor Black, please?
Through the mayor to council, as you can see, one of the comments from Public Works is that there are a variety of options that could be used with respect to that. The options that we have put forward for this are that we enter into an agreement with all of the property owners so that the existing lane I wouldn't even call it a lane, I'm going to call it the private driveway that's currently on the unopened, unmaintained right-of-way. We could ensure an agreement between all of the lot owners in that area who wish to be party to it to have access. That is one option. Another option that exists is that the people who are proposing to build on these lots would be required to construct a road to municipal standards, at which point we could open the right-of-way and turn it into a municipally maintained road. Or I guess the third option that we didn't put forward because we didn't have direction from council, but council could do that, is that a capital project be developed to construct a road to municipal standards. In this case, I wouldn't suggest an urban road be constructed. I would suggest that it would be a rural, likely a tar and chip road to be created. That's again another option that council could do. At this time, we didn't have any instructions from council to add any infrastructure to our asset list, and as such we didn't put that forward, but that's also something that council can consider should they wish to do so.
Okay. Mr. Mayor, through you to Lee, if the county built this road, to an acceptable standard, could we charge that back to each property owner through their taxes over, I don't know, 5 years, 10 years, or something like that?
Through the mayor to council, that the situation which you just outlined isn't possible. That being said, we could do it through a local improvement, and that would allow those sorts of things to go onto their taxes. If we did it as a local improvement, it could be charged back to all of those property owners.
Oh, and would we need permission from the property owners to do that, or could we just go ahead and do it?
Through the mayor to council, there is acts and regulations in place with respect to local improvements, and we do have to, if council's direction is to do that, then we have to go through that appropriate process, and that of course involves the ability of property owners to appeal should they wish to do so.
Thank you very much. Councillor Brunton.
Thank you, Mayor Luke. I'm trying to look on Google Earth here. I'm trying to get this thing straight in my mind, but there are 2 cottages existing now, or homes?
Through the chair, yes, that is correct.
Who are those owners?
Through the chair, we don't have those details in front of us at this time.
Well, they're large homes, are they not? And they were, like, were they not recently, like, how long ago were they built? Seems to me they look, if I'm looking at it, it looks fairly new, or the last few years, maybe?
Through the chair, they're in the report, under the comments from our building division, they have outlined, we've gone through the building files to determine what history we can find for these dwellings on Gowrie. We seem to have found permits for additions, alterations, variances, but there were no records in terms of the building files for those two dwellings. One, we did find some information on about a relocation of the dwelling from another location, but no specific building permits for those two were found.
Were there dates for any of that?
Through the chair, page 2 of the report, under building and bylaw, does show some of the dates for the building permits that were found.
And they all used the common road, or laneway, whatever you want to call it?
Through the chair, yes, that's my understanding.
Thank you.
Thank you, Councillor Columbus.
Councillor Brunton asked my first question, and my other question is with respect to, I read in here where the drainage ditch was actually on someone else's property that was adjacent to the road, the lane, I guess it is. Has that been corrected, or is the road, Cumberland Lane, in the exact location it's supposed to be now, or is it on some of the private residential property?
Through the chair, one of the landowners did mention that they believe they are encroaching on a portion of the road allowance along Gowrie Street. And then in terms of the drainage, it may be better directed towards the applicants. I believe Mr. Harris spoke to me about the drainage issue as well.
I see Ms. Robinson has her hand up to answer the question.
Through the mayor to council, with respect to that, that is not a municipal drain. That is some other drainage. My understanding is that it does vary between the municipal property and the private property in that area, and it's actually to provide drainage for, not for that private lane, but for some lands to the north.
So is that ditch within the county-owned property, Cumberland Lane?
It's both. It's on some private property and it's on some municipal property. Without having a definite legal survey done at this point, it's safe to say that it does meander between both pieces of property.
Thank you.
Thank you. Councillor Height, please.
Thank you, Mayor Luke. I'm looking on page 39 on the map there, and I'm through you to planning on Cumberland Street where it passes Gowrie. The southbound side of it, is that county owned? The stub of the road that's left?
Through the chair, in speaking with corporate services, I believe that yes, the stub heading down south is owned by Norfolk County.
Sorry, it's owned by the county?
Correct.
So we could surplus that and sell that off to, say, lot 5? Would that be big enough to be a building lot? You know?
Through the mayor, Councillor Height, that's a very steep transition from the roadway down to the lake, and it's quite eroded out through. There is I recall some drain tile that goes down through that area. I don't think it would be buildable, certainly not. Your suggestion, if it was declared surplus, probably make more sense to assign it onto an abutting property if there was a desire to do that.
Yeah, we will not be responsible for it. I already have an old mill road that's similar to that. But now on the, I guess it's the west side of Cumberland, that property there, if we had a real road in there, would you be able to sever those off as lots on the west side?
Through the chair, the west side of Cumberland is designated and zoned agricultural, so there would be no severance permitted in that area.
No, okay. And I noticed that our emergency services, they didn't have a comment other than of the snow, but don't they have a problem with dead-end roads? And I'm thinking Gowrie would have to be a dead-end road. I don't know how you would even get a turnaround in there.
Through the chair, yes, usually there is concerns with dead-end roads, but in this case, they've noted generally that there would be access concerns because of the road situation.
Okay, thank you.
Councillor Oliver, please.
Thank you very much, Mr. Mayor, for letting me speak again. This is just a real quick one, and I'll direct it to Ms. Robinson. The two houses that are located on Gowrie already, in terms of garbage and recycling, would they transport their garbage and recycling up to the Radical and we pick it up there on our road allowance?
Through the mayor to council, that was the instructions to the contractor, is that they were not to go down those roads to collect it. I cannot say whether or not they've made other arrangements with our collection contractor, as some people have, but our instructions to them is that they are not to travel down there, as the road is not, as it's not a road, it's actually a private driveway.
Right. Okay. Thank you.
Any other questions to staff? Okay, we'll proceed then. I'm going to now ask if there's anyone in attendance who wishes to speak in favor of the application to come forward. And certainly, as always, we give the first speaker the privilege of speaking first to the client or the agent. Mr. Klein, you're willing to speak, and I know you're here on the Murphy application only, correct?
Yes.
So we will let you speak to Mr. Murphy's application, and then I'll look if there's any questions to you, and then I will also ask the same for Mr. Harris, okay?
Thank you, Your Worship, and good evening, members of council. Let me sum up how I assess this right at the outset. It seems to me what you're trying to apply here are 2017 standards for a development that was approved in 1948. That's the reality of the situation. I have before me the plan, registered plan 228. First of all, Cumberland Street is designated as a street. Gowrie is designated as a street. Cumberland has frontage on Radical Road of 33 feet. Gowrie has frontage of 66 feet, 71 feet to be precise. The lots down on south of Gowrie Street, north of Gowrie Streets, are served with hydro, which has been installed. And I understand there's a gas line that goes down and services those properties. A registered plan 2288 was approved under Section 25 of the Planning Act 1946 by the Minister of Planning and Development. So in 1948, municipal councils, other than having some input to the ministry, really had nothing to do with the establishment of subdivisions back in 1948. Now, I took the liberty of pulling Section 25 of the Planning Act back in 1946, and I was quite struck by two facts. Number one, the Planning Act of 1946 was 10 pages long. I think our current Planning Act is probably, with regulations, 300 pages. It was all done 10 pages in 1948. The interesting thing when you read the Planning Act is that the criteria for subdivisions that the minister took into account do not vary much from the criteria that municipal councils today take into account. Access to roads, surrounding areas, what the use is in the areas, and if you go down to what I call subsection 50, subsection 24 of the current Planning Act and compare it to section 25 of the 48 Planning Act, you won't see much variance. Now in this situation, what you have are two issues that council has to grapple with. Number one is the official plan amendment dealing with the construction of the residences, I'll say residences, in hazard designated land. That issue has been addressed by the planning department. They're satisfied based on the input that they've received from Long Point, based on their own investigations, that a development envelope can be created in that hazard designated property. So from my perspective, that issue, given that finding by the department, is really off the table. The more fundamental issue that seems to have everybody hung up is the road issue. And I'm going to be perfectly blunt. That's your issue. That is the issue for this council. That's not an issue for these ratepayers. Why do I say that? The Planning Act is a double-edged sword. I've handed out to you the provisions of the Planning Act. Mr. Clerk, did you hand those out? All right. Now, if I can ask you just to look at those provisions. You must bear in mind that municipal bylaws are subordinate to provincial legislation. Here's the provincial legislation under section 34(1). Zoning bylaws may be passed by the councils of local municipalities restricting land use for prohibiting the use of land for or except such purposes as may be set out in the bylaw within the municipality. So that's the general authority for the council to impose restrictions. Now we jump down to 34(5). What can they do? A bylaw passed under paragraph 1 or 2 of subsection 1, or a predecessor of that paragraph, may prohibit the use of land or the erection or use of buildings or structures unless such municipal services as may be set out in the bylaw are available to service the land, building, or structures as the case may be. Now that's the legislative authority that the council is relying on for your 2004 or 2005 bylaw. There's your legislative authority. The parent legislation have said you can do that. Okay? But let's move on to the next section. And what I would ask you to do is to take your pen and stroke out the words that I tell you to stroke out and read through. It says, accepted lands and buildings. No bylaw passed under this section applies. Underline the word applies. To prevent the use of any land. Strike out building or structure, because it doesn't apply. Was lawfully used for such purpose on the day of the passing of the bylaw, so long as it continues to be used for that purpose. What was the use of the land subsequent to 1948 in this area? As a road. What's its use today? As a road. It has the status of a legal, non-conforming use of land, albeit municipal property. So the sum and substance of my submission to you is that this particular provision of the bylaw, while it's relevant, doesn't apply in this particular situation. What you're doing is you're relying on the secondary document being the bylaw, but you're ignoring the legislative parameter, which is the provincial law, which says the bylaw does not apply. Now, this issue is not a new issue that's come before the courts and come before the OMB. They've tried various things to get around this issue of legal nonconformity. For example, your current bylaw says that a street is a permitted use in any zone in Norfolk County. So, theoretically, Cumberland Street is permitted. So the question that has to be asked, well, if all streets are permitted, Klein, how do you establish that Cumberland Street is legal nonconforming? I don't care what your bylaw says. I'm relying on what the Planning Act says. And the Planning Act says, so long as there's continuity of use from the date of establishment, legal nonconformity is established. Now, I just want to quote one issue from one of the cases to make the point. The bylaw, and this is a case out of London, 382671 Ontario Limited versus London. The bylaw, they're talking about the zoning bylaw, is an instrument that is subordinate to the Planning Act. The courts have made findings repeatedly, as for example they give a number of cases. In that case, a new zoning bylaw contained a provision purporting to deem legal non-conforming uses to be conforming. Colleen J. stated, there is a substantial measure of operational disunity and inconsistency between the bylaw provisos of the subordinate instrument and the protective, and that word is protective, proviso of the parent statute, such that the bylaw provision must fail. If the municipality wishes to obtain the power set out in the bylaw, in other words, the power to limit restricted construction, in this case, to updated, up-speed roads, it's got to say so by way of legislation. I mean, those are my words. The case goes on. The municipality must seek out an amendment to 34.9 and not take it upon itself to amend the statute through the subtle but illegal sleight of hand device. So the bottom line in my submission to you is that while the road's important, it really is not a land use issue in this instance when you're considering a land use bylaw given this particular set of circumstances. The road's there. The road's been there. Building permits have been issued on the basis of that road. We have houses built there. I think it's a little late in the day in 2017 to come up and say, well, you know, we know that this has been there since 1978, but before we're going to allow construction, which the planning department says the sites are available, you've got to bring up the road. Subject to questions, that concludes my submission.
Thank you very much, Mr. Klein. Are there any questions to Mr. Klein? And again, we're just dealing with his presentation on the Murphy application. Councillor Brunton.
Thank you, Mayor Luke. My question's for you to Mr. Klein. Mr. Klein, I'm looking on page 38 of our agenda, and there are 10 lots there by...
I'm sorry?
There would appear to be 10 lots in that area.
Yes, there are.
Okay. Mm-hmm. And 2 of them are built on?
Yes.
But one of them, I think it's 8 and 9, shows one parcel. Is that... Have they been amalgamated or through ownership somehow?
No. Yeah, there's 10 lots on there, but you bring up a very valid point.
Yep.
And the point is, this registered plan, notwithstanding it was registered in 1948, has never been deregistered. Okay. Any registered plan of subdivision after it's 8 years old can be deregistered. Now, what the impact of that is that if I own 10, 9, and 8 in my name, at the moment I can convey 10, 9, and 8 if the plan is deregistered, I have to convey 10, 9, 8 together. In other words, the subdivision of that land is gone if the plan's been deregistered. This plan has never been deregistered. I hope that's of some assistance to you.
Well, I'm maybe these were model homes that were built there, were they or no?
No.
So are you, I guess why is it in Dover all the time we have these problems? Sorry, Mr. Wells, but are you under the assumption, if we approve this, that the other lots can be built on too? Does that make sense?
Yes, of course.
Do you agree that we should have a road built in there properly?
Probably from the point of view of 2017 standards, I'm not going to argue against those, but the reality is, you have to look at 1948 standards. Are you going to go down to Turkey Point, upgrade all those roads in there?
Well,
are you going to go to Long Point, all those narrow roads?
Well, I guess what I'm saying is we have a lot of unopened roads around the county.
You don't, and you have an awful lot of them on all your hamlets. I can name you probably 4 or 5 hamlets where you've got situations exactly like this. Nobody has determined that they want to develop, but those lots have never been deregistered.
Do you think it's wrong that we ask the owner to build a road?
I think it's certainly open to the municipality to say, hey, can we get together here and do something about this? But I think it's, I don't think it's right, and I don't think it's legal to put a gun to the heads of the owners.
Well, no, but I just ask you, if we have 10 lots, and I don't know if there's still 10 lots there, but if we allow this and we build 10 more homes, or, sorry, we got 2, so if we build 8 more, we should have a proper road.
Well, you can use
that makes sense?
You can use that argument in many places in Norfolk County. You should have proper roads.
Thank you very much.
Thank you, Councillor Brunn. Councillor Oliver, please.
Thank you, Mr. Mayor, and thank you, Mr. Klein, for your comments. My question is pretty simple, and if you don't want to answer it, we'll ask Mr. Murphy, and I understand you can't speak for Mr. Harris, but is your client, as far as you know, should he get permission to build his home, is he prepared to use the road as it exists today?
Certainly. Certainly he is. And that's
so he has, as far as you know, he has no expectation on the part of the county that we're going to go in there and upgrade the road to some significant degree. Okay. Thank you.
Councillor Wells.
Thank you very much, Mr. Mayor. Just a question through your legal expertise. Should we grant the building of these homes and a fire should take place, would we be held accountable in any way for allowing those homes to be built? I want you to use your legal opinion.
I think the argument that you would advance is much the argument that I've advanced today, that, you know, you can't put 2017 regulations in a 1948 subdivision. And I mean, that's the reality of it. And as I said, you know, you can, if liability is an issue, put a sign up. Put a sign up. It's not maintained, it's not snowplowed. It's up to the ratepayers to take that obligation. I mean, this idea that you become insurers ad infinitum, I just don't buy it in this particular situation. I mean, to follow that logic, we could go back and sue the province in 1948 for giving its approval initially.
Thank you, Mr. Mayor.
Thank you. Any other questions for Mr. Klein? I don't see it at the moment. Thank you, Mr. Klein. There may be something further. I don't know. Mr. Harris, do you wish to speak to this application? If you please come to the microphone, and there's a little blue button on the right side of the box that says talk. If you give that a push, we'll be able to hear you, please. Just pull that microphone down to a little. There, now you're all set. Thank you.
Thank you. Tom. Leave it on, okay. Tom's a real hard act to follow. I'm going to be a little lighter than that. I'm not a lawyer. Mr. Mayor and members of council, staff, I'm Bob Harris, who, along with wife Sheila, have owned Lot 2, Gowrie Street, Port Dover since 1999. Lot 2 is a lot of record, part of the Flimby Park subdivision circa 1948. Some of this is Tom's already gone over. It's a beautiful building lot, a little over half an acre, 80 feet or 24.5 meters at the road, gently sloping to a sandy beach, and 91 feet, 27.7 meters of Lake Erie waterfront. The top 1/3 is clear, and the bottom portion trees and flora. Building on this lot has been classified as infill. Improvements over the years. At the shoreline, Tove Bluff erosion abatement, concrete blocks which are 5 deep, resulting in no erosion for more than 30 years. To the immediate west, a groin, this is between lots 1 and 2, groin breakwater was constructed, creating a deep sandy beach with minimum wave action impact. Now, normally the winds are prevailing out of the southwest, and that groin does a great job of making sure that erosion doesn't take place. On my property, but between lots 1 and 2, is a drainage gabion for surface water. That drainage gabion is 10 feet wide, 10 feet deep, and is constructed of steel mill slag, constructed along the entire western lot line. So surface water funnels between lots 1 and 2 right down into Lake Erie. It's slowed down, seeps in, and is released on the sand and into Lake Erie. Zoning. Upon implementation of the current official plan, the zoning changed from 1/3 agricultural and 2/3 hazard land to suddenly 100% hazard land. Now, prior to this, I delivered depositions, attended meetings, and wrote letters of opposition, which had no effect. I will never agree that this lot is hazard land. Slope stability assessments. To prove that lots 1 and 2 were buildable, a slope stability assessment was carried out by soil mat engineers in the summer of 2015, which concluded that, and I'm going to quote, and you have the reports, single-family dwellings may be constructed on the subject lots uphill of the established top of stable slope, without any negative impact on the stability of the subject slope from a geotechnical point of view. So they're engineers, they're doing a technical analysis, obviously. And a copy was sent to Long Point Regional Conservation Authority. So in January 2016, we had a meeting with Long Point Regional Conservation Authority, including soil mat consultant Ian Shaw, professional engineer, and Long Point Regional Conservation Authority agreed with the assessment, and it was decided that what we should do is a second site-specific deep borehole assessment to have it take place to maximize the site of the development envelope. In doing a forensic review of the first study, there were some errors in the soil mat. Some of the setbacks were applicable down in the Hamilton area, but Long Point Regional Conservation had different setbacks, for instance. So we corrected that. The other thing was, the first study, they simply went to the north side of the traveled road of Gowrie Street and took all their measurements from that direction. So I said to Soil Mat at the time, I said, I'm sorry, but we want it from the lot line. Okay, we want the Long Point Conservation Authority dimensions changed. We want everything referenced from the stake, a surveyor's stake, at the lot line. Would you now bring the truck in, dig the hole, dig the bore, and let's get a better review of what it really is. So June 2016, the supplemental assessment took place. It's referenced in your planning application survey. Using this assessment, Long Point Conservation Authority approval and direction from Norfolk County Planning, the development envelopes for both lots and 2 are defined as shown on our planning applications. To conclude, my planning application does not request a zoning change from HL, even though I disagree that it should be HL, only that based on the soil mat geotechnical assessment approved by Long Point Regional Conservation Authority, we be approved to construct a single-family dwelling within the development envelope. On March 25th, 2014, this council unanimously approved, and I'm going to quote, to support the principle of residential development on lots 1 and 2. I'm requesting approval of my planning application. Thank you.
Thank you, Mr. Harris. Are there any questions from members of council? Mr. Harris, Councillor Wells, please.
Thank you very much, Mr. Mayor. And just for clarification, you own lots 1 and 2?
No, Lot 1, and Paul Murphy owns Lot 2.
Okay, so you are requesting eventually to build a house on Lot 1?
Lot 2.
Lot 2. And Mr. Murphy is requesting to build a lot on Lot 1?
A house on Lot 1, yes.
Okay, that's all I needed to know. Thank you.
Thank you, Councillor Oliver.
Thank you, Mr. Mayor. Mr. Harris, you heard me ask Mr. Klein the question about his client's expectations, if any, in terms of the road, the access. Should you be granted permission to build your home, are you satisfied with the condition of Gowrie Street and Cumberland for your use as they presently exist?
Well, 2003, I was, along with Paul Murphy, involved in the upgrading of Cumberland
Yes.
Road, Cumberland Lane.
Lane.
Yeah, that Mr. Ivey used to refer to as, he was on the original council, the late Gord Ivey. And so Cumberland Lane, we contributed, that was myself, Ron Sinden, and Paul Murphy, with the help of Norfolk County, in upgrading in 2003 Cumberland Lane. And that lane is adequate to service 2 more houses. There's 2 down there now and 2 more to come. In my opinion, that road is adequate. But I would project in the future that probably the property owners would want to maintain it, but that's at a later date to decide.
Okay, but your comments to me were only about Cumberland. Gowrie, I mean, your lot is at the extreme west end of Gowrie, along with Mr. Murphy's. Are you satisfied with the condition of Gowrie in its present condition for your use? Should be given permission to build a home there?
Well, right now, Gowrie Street is on the southern portion. The travel portion is on the southern part of Gowrie Street, which is a 66-foot road allowance. Yep. Anybody that builds down, it's a tight little area down there, anybody that builds down there will have to improve that portion of Gowrie Street.
Okay, then I need to rephrase my question. Are you satisfied then that if you feel any improvement is going to be needed for you or Mr. Murphy's lot or for one of the other lots that's still vacant down there at that far west end, that you would be responsible for upgrading it for your use?
That portion of it?
Yes.
Yes.
Okay, thank you.
Councillor Brunton.
Thank you, Mayor Lukes. Mr. Harris, sorry, when did you purchase the lot?
1999.
Okay.
Yeah, I think January and February.
Again, I'm looking at page 38, and lots 1 through 5 are all on hazard land. Were you aware of that when you bought it?
Oh, no, it wasn't hazard land. It was agricultural.
Was it designated hazard land on this
No,
map, the way I
not
read it?
in 1999. 1/3 of it was agricultural, 2/3 was hazard land. So when I bought it, I was buying a pretty generous building envelope, or development envelope, because the top third was agricultural. And I think that one of the meetings with planning, Kayla, you threw up a slide that actually showed the original the top half of lots 1 and 2, how it was zoned prior to the official plan coming into. But about 1/3 of it was agricultural.
But it could still be in hazard land.
No, it wasn't in hazard land. The bottom 2/3 was hazard land.
Your Worship, I need some clarification on that.
Let's get it. We won't get in a debate with our applicant. Kayla, can you clear up what the zoning is at this point?